Is it on behalf of people, Your Honor?
Anybody make a decision?
Yes.
Thank you.
Stephanie Canna on behalf of Mr. McLean. Please state your name for the record.
Matthew McLean.
If you must, yes. All right, record should reflect we've had a bench conference in this case. Go ahead.
It's fine. It's come to my attention that Mr. McLean has not been directly contacting the victim, but I have come to find a few jail calls that concern me and what she's telling his family members, tell her that he loves her, as well as also mention to those specific family members who he's trying to get to be in contact with the victim, that if she does not show up, then the case would be dismissed, and suggesting things of that nature to them as well. So I have concerns, given that at first it's just to reach out with my love yous, but then it's also suggesting outcomes that could interfere with this criminal case. So at this time, I'm going to be asking that the defendant be remanded and that text privileges in the jail where you want to give it.
And Your Honor, in response to that, there's been no evidence presented whatsoever that any information has been communicated to the complaining witness in this case. And just because he has knowledge of how things typically go in this matter and has expressed that knowledge is not indication that he has been trying to tamper with the case or the witness in any way, shape, or form. He's not in communication with her now. He's very concerned about her now. I told the court, and that's because there's been no communication whatsoever. She has been on repeat calling his family, and there'll be evidence of that if we do proceed further, trying to see what she can do to get the case dismissed. And that's evidence that we are going to be presenting to the court and her taking culpability for the incident as it happened. I understand the prosecutor's position. And my client since then has not made any communication, reached out any way, shape, or form. Matter of fact, when he came in, because she has stopped communicating with her family and his family, he wanted to know if it was okay to call to get a welfare check on her because he knows her mental health status and her drinking status. Your Honor, my client has, as soon as he got out, he went and checked himself. He went into the Don Farms outpatient program?
I'm accepted for inpatient.
Into their inpatient program because he understands that a part of this incident stems from both of them and their sobriety and challenges with sobriety. So as soon as he got out, he came in and told me this is what he was doing. And I told him that's really good.
I have an official letter.
And so he is trying to fix this and straighten it out. He is aware that he cannot communicate with her directly or indirectly, Your Honor, and he will not be doing so.
At this stage, the hearing has shifted away from the underlying criminal allegation and toward a completely different legal issue, whether the defendant can be trusted to follow the court's conditions while the case is pending. Notice that the defense isn't arguing innocence here. Instead, counsel is strategically highlighting rehabilitation, sobriety treatment, and the absence of direct contact with the complainant. Those facts are designed to show the judge that the defendant is trying to comply rather than undermine the judicial process. The prosecution, however, is focused on something equally important: indirect witness influence. Even if there was no direct message to the complainant, courts take allegations of communicating through relatives or mutual contacts very seriously, because those communications can potentially affect a witness's willingness to participate. That's often enough to trigger judicial concern before any trial testimony is heard. Did you notice how both sides are arguing about intent rather than proof of the original offense? That's because bond conditions exist to protect the integrity of the proceedings. If the judge believes those conditions are being tested, the consequences can become immediate, even before guilt or innocence is ever decided.
Yeah, but they're repeated indirect calls. As I indicated to counsel, the concern sometimes when you get the I love yous, that could be concern. When you get wanting to check on somebody, can be a concern. I don't know that from the court's perspective that is such a concern, but when you start talking about how the case to these same third parties about that. Basically, if she doesn't show, then the case gets dismissed. And you're telling them, in essence, to communicate certain things to this person, that becomes a problem. And he shouldn't have been doing it in this case, or certainly have made it clear. He shouldn't have been communicating to third parties about her anyway. Some of it might be able to be excused, but I can't excuse that. So what I'm going to do is I'm going to adjourn the probable cause conference to.
Oh, Your Honor, we were asking for the exam to be set.
Okay, then it won't be addressed till the 21st, if that's what you want me to do. Otherwise, I'd give you a week, the 16th, your choice.
The 16th, Your Honor. We'll take the 16th, Your Honor.
I'll adjourn probable cause conference to July 16th, 2026, 9 a.m. At this point, given what the court has heard, defendant's bond is ordered revoked, defendant's remanded.
Judge Simpson's decision illustrates an important distinction that many viewers overlook. Bond revocation is not a punishment for the charged offense. It is a response to the judge's assessment that the defendant may no longer be complying with the conditions that justified release in the first place. The court specifically distinguishes between expressions of concern, like asking about someone's welfare, and discussions that could influence the complainant's participation in the case. That distinction matters legally. The judge also explains his reasoning instead of making a blanket accusation. He acknowledges that some indirect communications might be understandable, but discussing possible case outcomes through third parties crosses a line because it risks interfering with the judicial process. That measured explanation strengthens the record if the ruling is later reviewed. From a courtroom strategy perspective, the defense presented evidence of treatment and rehabilitation, but those positive developments could not overcome the court's immediate concern about protecting the integrity of the case. Do you think the defendant's efforts toward sobriety should outweigh allegations of indirect witness influence, or is preserving the fairness of the proceedings the higher priority? That's exactly the balance the court is attempting to strike here.
Ms. Winter, when you arrive, please state your name for the record.
Leah Winter.
Thank you, Judge. She spoke with my intern at the jail the other day. My understanding is we're still working on trying to reach a resolution. If we can have a brief adjournment, we'll continue to get this matter resolved.
July 23rd, 2026, 9 a.m. Bond continued. Thank you.
I'll send Muhammad back to confirm. She wants me to ask for a bond, Judge.
Okay.
Would you mind if I do that? Thank you, Judge.
I don't think you want me to answer that, but go ahead.
Well, thank you for allowing me anyway.
Yeah.
In speaking to my client, it sounds like she has indicated that she will return to court should the court allow her an opportunity for a bond, not resources financially to be able to post the current bond. He's asking the court might consider a PR bond or a 10% bond, at which point I hope she could post that and she would return for all future court dates.
I've got no by tomorrow. I was under the impression he gave me a PR already 2 weeks ago.
Judge Simpson did?
Yes. Then you.
What?
She says she's under the impression you may have already given her a PR bond on this file 2 weeks ago. Is that what your file reflects?
Okay.
You say a couple of weeks ago that I gave you a...
The last time I seen you told me to show up to court and you did offer me a personal recognizance. I got my holds taken care of and I've been in custody.
Slow down.
Sorry.
You're going too fast. Say it again.
I said, it's in the file.
Going too fast for him.
Sorry.
Go ahead.
I said that last time I seen you, you offered me a personal recognizance. I had my holds be taken care of. They did. Novi expects me in person tomorrow. And we've been under the impression that I had a PR.
She was moving too fast for me, Judge. What I think I heard her say is that 2 weeks ago, you told her that if she got all her holds in other counties cleared, then the court would entertain the possibility of a PR bond.
That sounds like something I would say. I don't.
That's all those holds are now cleared.
Some cash or surety
Currently.
Thank you.
All right, but okay, so in the interim, she's gotten her holds cleared up.
Correct, Your Honor. She says she does have a court date tomorrow in Novi,
Which
and she is supposed to be there in person. So she requested the court allow her a release.
Got it. Do the people see that? Or-
I'm double checking actually right now, Your Honor. I think part of the concern was there was a missed court date and defendant indicated she was in South Dakota at the time of one for BCC. So there was a bit of a concern about flight risk, but
She said she was in South Dakota to me.
Yes.
I would have remembered that.
Yes,
I
I
think
was.
she said it's Magic Hotel, Your Honor.
Oh,
Do you have an address to say with
I
my
don't know why. What was it? What's in South Dakota?
my mother? She just had surgery on this.
Oh, okay.
But I'm not leaving. I have a place to live in Adrian with my uncle, her youngest brother, Joseph Hunt.
I see 2 holds out of the next jail. One Novi and one MSP.
And
So I'm not, the MSP appears to be in traffic and Novi looks like drug paraphernalia. I don't know if they would get her or not, but I still see 2 active holds. They may be cleared just with the next jail.
But right, correct. That's because she says she has a hearing in Novi, so it sounds like that one was cleared. They're
And then
gonna
it's
have
not coming
to
again.
walk in, right?
That's correct, Judge. The Novi is cleared.
And then you got an MSP one that's probably, you think it's probably in traffic.
Yes, she says they've indicated they will not come get her.
They
And
will
then
not.
there's a $1,000, 10% bond here on the misdemeanor case before Judge Washington, it looks like.
turn this to PR if I get a PR here. So
That's all I see next year.
She says Judge Washington has indicated that that bond will turn to a PR bond if she gets a PR bond here. So we just have to notify her that this court has allowed her.
It sounds like Judge Washington to leave it up to me.
Well, I don't know,
Just
Judge.
saying.
Maybe she deferred to you on this one. She wouldn't have any objection to a tether if necessary to help address the people's concern.
yes.
I'll read. What is Acton really saying now?
That's good. Pull up Judge Washington's notes on court index.
Oh, she knows how to do that? Okay, go ahead. What does it say? Did she put the notes in? Or
Notes says Ashley motion. So
it's from Ashley?
yes,
Okay, go ahead.
this inclined here for pretrial custody, bond reduced to 1,010% to convert to PR if released out of this fine.
I have court August 3rd too.
Yeah.
And then Novi tomorrow.
During the agree to see results.
So sorry, according to the law, do grant $25,000.
I think I did. I thought as we were talking that I already did, but
Perfect.
Yeah.
so
We don't need anything.
so Fisher has been, they're wasting my time.
I took
Yes, ICR, but they never got it.
They're wasting my time, and then Acton really joined in, wasting my time. I could have been done with the whole docket by now. I thought I had given her that.
I owe you 5 minutes, Judge. I'm sorry.
Not a bad dispo.
I mean, I weeks of my time.
I know. It's all time I don't get back. All right. I don't know any.
It was the 23rd.
23rd.
Yes. Thank you, Judge.
You're welcome.
So what do I tell ITR? Because I've been telling them.
What do I tell ITR? Have no clue.
Ms. Welding is gonna.
We will make sure.
Okay, thank God, because I missed my mom's surgery and
Okay, hold on.
okay.
We'll make sure that a proper dispo gets down indicating that your bond here is a PR. I think that the only thing that may need to follow is that Judge Washington's bond, that somebody
I'll reach out.
lets them know.
Yes, Judge.
Thank you.
You're welcome.
Yeah.
Okay.
All right.
Thank you.
No problem.
Thank you.
Take care.
That's the most Feaster talked in like a long time.
I'm trying to be quick.
No, you try to be quick. And then Akin really stepped in and we were going to be here all day. So she doesn't know. She doesn't know where she's going. Excuse us. She doesn't know where she's going to go in line. Oh, because then we can get. She's hungry too. She's hungry too. And the mom's watching, so everybody, huh? Oh,
These two hearings
Yeah.
demonstrate that pretrial proceedings often revolve around procedure, compliance, and judicial discretion rather than determining guilt or innocence. In the first matter, Judge Simpson concluded that protecting the integrity of the criminal process outweighed the defendant's request to remain on bond. The concern wasn't simply whether communication occurred, it was whether conversations through third parties could influence a witness or interfere with the case. That is a legitimate factor courts routinely consider when deciding whether bond conditions remain appropriate. The second hearing shows a very different exercise of judicial discretion. Instead of focusing on possible interference, the court carefully worked through bond records, outstanding holds, scheduling conflicts, and prior rulings to ensure the defendant received the release status the court had previously intended. Rather than rushing to a decision, Judge Simpson verified the paperwork and corrected what appeared to be an administrative misunderstanding. That careful review reflects how important accurate court records are in pretrial proceedings. One broader lesson from today's docket is that credibility and compliance matter every time someone appears before the court. Judges are constantly evaluating whether defendants follow instructions, whether attorneys present reliable information, and whether court orders can be trusted moving forward. What part of today's hearing stood out to you the most? The bond revocation over alleged indirect communication, or the detailed effort to correct the second defendant's bond status? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.